Seconds to go. Start. The petitioner, who was a constable in the UP police, was dismissed from service by order dated 28th January 1994 for the reason that he had unauthorizedly remained absent for a long period of 503 days from 8th May 1992. The appeal filed by the petitioner was rejected by order dated 27th July 1994, and the claim petition number 1287 of 1995 filed by the petitioner before the UP Public Services Tribunal was also dismissed by order dated 1st December 2009. This petition has been filed to assail the aforesaid orders. The facts reveal that while the petitioner was posted as a constable in Saharanpur, he was directed to take part in the refresher course in the police training center at Moradabad. He was relieved on 3rd May 1992 by the authority to undertake the course. The petitioner, however, did not report at the training center and went to Deoband, where he was admitted in a government hospital. It is stated that he was asked to take rest for 2 days. The petitioner thereafter proceeded to the training center, where again fell ill and was admitted to a government hospital at Muzaffarnagar, where he was advised to take rest for 2 days. It is stated that the petitioner thereafter went to the police training center at Moradabad on 8th May 1992, but he was not permitted to join the refresher course as he reached late. The petitioner claims that while returning from Moradabad, he had some kidney problem and therefore could join his duties at Saharanpur, and he went to his residence at Muzaffarnagar and stayed there for treatment of his disease. As the petitioner unauthorizedly remained absent for a long period of 503 days without leave or permission, a charge sheet dated 1st June 1993 was issued to the petitioner. The inquiry was conducted against the petitioner under the provisions of UP Police Regulations 1861, and an inquiry report dated 5th January 1994 was submitted. The inquiry officer found as a fact that the petitioner had remained unauthorizedly absent for a long period of 503 days. The medical reports of a private doctor were not believed. The inquiry officer noted that the petitioner did not get himself examined in a district hospital as was the requirement under the regulations. The petitioner was provided an opportunity to submit his objections to the inquiry report, which opportunity was availed. Subsequently, a detailed order dated 20th January 1994 was passed by the Senior Superintendent of Police Saharanpur for dismissal of the petitioner from service for having remained unauthorizedly absent for a long period of 503 days. The appeal filed by the petitioner was dismissed, and the tribunal also dismissed the claim petition filed by the petitioner. The only submission advanced by learned counsel for the petitioner at the time of hearing of the petition is that the punishment of dismissal from service imposed upon the petitioner is disproportionate to the charge that was levelled against the petitioner. Ms. Meenakshi Singh, learned standing counsel, appearing for the respondents, has, however, submitted that the punishment of dismissal imposed upon a constable for having unauthorizedly remained absent for a long period of 503 days cannot be said to be disproportionate. Learned standing counsel placed before the court the judgment of the Supreme Court in State of UP and others versus Ashok Kumar Singh and another 2017 to SCC, and had submitted that the scope of judicial review of punishment awarded by the disciplinary authority is extremely limited, and the courts would interfere with the quantum of punishment only when the punishment is found to be shockingly or strikingly disproportionate to gravity of misconduct. Stop.